Hi, I am Dark Blue, an ICE 50 avatar, and will present this interesting article. California Statute of Limitations 2 of 2. California caps non-economic damages in medical malpractice cases. Learn about that and other important state laws. Updated by David Gogwin, JD. California's cap on non-economic damages. Legislation signed by Governor Gavin Newsom in May 2022 increases the non-economic damages cap for the first time since 1975, effective January 1, 2023. The new caps apply to all cases initiated on or after that date. For 2023, the caps are set at $350,000 for malpractice-related injuries that do not involve wrongful death, and $500,000 for medical malpractice that resulted in wrongful death. Beginning in 2024, the dollar amounts will be bumped up each year by $40,000 for personal injury and $50,000 for wrongful death, until 2034 when the caps reach $750,000 and $1 million, respectively. At that point, the amount will be adjusted annually by 2% to account for inflation. It's important to keep in mind that the $250,000 cap will still apply to all cases filed before January 1, 2023. You can read the full text of the legislation, AB 35, on the California Legislature's website. Note that this cap, which can be found at California Civil Code Section 3333.2, has no bearing on economic losses like past and future medical care made necessary by the malpractice, lost earnings, lost ability to make a living, and other quantifiable financial losses, past and future, resulting from the healthcare provider's mistake. Limits on attorney's fees in California medical malpractice cases. Medical malpractice plaintiffs' lawyers almost always work on a contingency fee basis. Under California Business and Professions Code Section 6146, there is a sliding scale limit on the percentage an attorney can charge in a medical malpractice case. The structure is as follows: 40% of the first $50,000 recovered, 33 1/3% of the next $50,000, $50,001 to $100,000, 25% of the next $500,000, $100,001 to $600,000, 15% of any amount over $600,000. Shared liability rules. In some medical malpractice cases, the defendant may argue that you are at least in part liable for causing your own injuries by, for example, failing to follow a healthcare professional's instructions. If you go to trial and are found to be partially liable, that finding will reduce or even eliminate your damage award, depending on state law. California follows a pure comparative negligence rule. This means that, if you are found to bear some negligence with respect to your injury, illness, or medical condition, your award of damages is diminished in proportion to your fault. If, for example, you were awarded $100,000 in damages, but were found 20% at fault, your damages would be reduced to $80,000. Legal notice. This article is for informational purposes only and does not constitute professional advice. The views expressed in this article do not necessarily reflect those of ICE 50. One must consult with their legal representative for any and all legal advice.